Otherwise, it is Chikkaballapur. And we had already promised that we will be coming out with the second part of probable defenses in the partition suits. But today, there will be more emphasis on the judicial journey as such on this aspect. Since tomorrow we have Christmas and the people are in a celebration mood, we thought we should start perfectly on time. And as such, without taking much time, I will request Mr. Rao to share his knowledge. Over to you, sir. Mr. Rao.
Good evening, everybody. This is the second part of my lecture. The first part basically focused on two important aspects. The first aspect was when property is acquired on succession to a male, the property is acquired by them as tenants in common and not as joint tenants. And I dealt with the matter as to what happens to the property in the hands of the persons who succeed to the property, and what is meant by tenancy in common and what is meant by joint tenancy. I also made a reference to a few decisions where property is acquired by a member of the joint family. Whether it would be joint family property of the parties or it would be self-acquired property of the person who has acquired the property in his name. These two aspects I dealt with in my last lecture. Now I go to a few other aspects of the matter. And the next question that I would like to take up for a discussion would be where property is acquired in the name of a junior member of the family, in what circumstances the property would be joint family property. In fact, the question is covered by a decision of the Supreme Court reported in AIR 1966 Supreme Court 411, A. Nair versus G. Amma. In this case, a decision of a bench of 3 judges, Justice K. Subbarao has delivered this judgment. And in this judgment, it is clearly stated that there is no presumption normally where property is acquired by a member of the joint family and the family had sufficient nucleus out of which the property in question could have been acquired, then the presumption is that the property belongs to the joint family. But where the property is acquired by a junior member in his name, there is no presumption at all. The court will have got to investigate the facts and try to find out whether the money utilized for the purchase of this property by the junior member was in fact acquired with the funds belonging to the joint family. So if this connection is not available, then the property would continue to be the self-acquired property of the acquirer, though he is a member of the joint family. Now there are 2 decisions of the Karnataka High Court in this regard. One is a decision reported in AIR 1973 Mysore, page 113, Shivaji Rao versus Rukmini Amma. This is a case in which Justice E.S. Venkatraramaya has delivered the judgment. I read only one paragraph from the head note. Ordinarily, when a property stands in the name of a junior member of the family who is not functioning as manager, the property would be considered as belonging to him until it is established by other persons who claim that the said property is joint family property by adducing reliable evidence showing that it is joint family property. if any evidence is forthcoming that the money utilized for buying the property belonged to the family, then the said property would be treated as joint family property. So therefore, the court has said there is a presumption. The presumption is that it belongs to the joint family member. And the person who asserts that the property is joint family property will have got to lead evidence to connect that the consideration for the purchase of this property flowed from joint family funds. In this particular case, which was before the Supreme Court, which was before the High Court, their lordships have made a reference to the various account books maintained by the joint family in respect of the business of the joint family. In those account books, the advance for purchase of this property and the consideration for purchase of the property was all had been supplied by the funds of the family generated by the joint family business. So therefore, in that particular case, the court held that the property did not belong to the junior member exclusively, and it was joint family property. Then there is one other decision of the Karnataka High Court when their lordships have considered this matter, and that is a decision reported in ILR 1987 Karnataka, page 2883. In fact, how the evidence has got to be adduced has also been stated in this decision. In the case of acquisition by a junior member of a joint family, the fact that the joint family possessed considerable nucleus capable of yielding income sufficient to enable the acquisition of the property is not by itself sufficient to hold that the acquisition by a junior member of the joint family is with the aid of the joint family, and the presumption to that effect cannot be drawn. It shall have to be proved either by showing that it was acquired by the joint family funds, or by proving that such junior member was in charge of the management of the joint family property or business, though not the karta of the family, capable of yielding income so as to enable him to purchase the property. In the latter case, if such junior member was not able to show that he had independent source of income or consideration to the acquisition of the property had flown from particular source not connected with joint family property, a presumption shall have to be drawn that such acquisition of property was with the aid of the joint family funds, in as much as in such a case the junior member being in possession and management of the joint family property or business, his position will be akin to a karta. So therefore, the most important thing is, if you are appearing for the defendant, see, if the way you have got to cross-examine is that on the date when the property was acquired, he was not in the management of the joint family properties. Suppose it is admitted by the parties that the senior most member was in the management of the family properties, it is better to not to ask further questions in regard to the management of these properties. Because when once it is admitted that the senior member of the joint family, who is the karta of the family, is in the management of the affairs of the family, the income from the joint family funds does not flow into the hands of the junior member who has acquired the property. In such a situation, your defense that the property is not joint family property, but it is self-acquired property of the junior member would succeed. So therefore, a careful pleading has got to be made, and a careful cross-examination should be there, so as to guard the interest of your client, that the property purchased by him being a junior member of the family does not belong to the joint family. So this is one aspect of the matter which which arises on various occasions in a number of cases in which we appear. Then the next question I would like to deal with is where property is acquired in the name of a female member of a family. What should happen? Whether such a property could be joint family property or not. This, in fact, in most of the cases, the father purchases the property in the name of the mother or the daughters who are unmarried. Therefore, in such situations, we will have to defend our clients to say that the property purchased by the female member belongs to her exclusively and it is not joint family property. In fact, I would like to invite your attention to a decision of the Supreme Court reported in 2009 SAR Civil, page 728. This was a case arising out of a dispute from Karnataka, and what had happened was a few properties were acquired in the name of the mother-in-law. It was a suit for partition by the daughter-in-law against the mother-in-law and others. The father-in-law was dead. So some properties were acquired in the name of the mother-in-law. So the contention was that the mother-in-law had no independent income of her own. Therefore, these properties which are though purchased in the name of the mother-in-law or purchased by the father-in-law with the funds belonging to him, and therefore they are also joint family properties. The trial court decreed the suit in respect of the properties which were acquired in the name of the mother-in-law. The High Court upheld it, and this is how the Supreme Court has said that by operation of Section 14, that this property would become the self-acquired property of the female, and it does not become joint family property. I would like to make a reference to a few paragraphs in the decision of the Supreme Court. This is what the High Court said. I read from paragraph 11 of the judgment. In the first appeal, the High Court found that no evidence was adduced by the appellant, that is the mother-in-law who had filed the appeal, to show that she had any independent source of income. It has also come in evidence that at the time of death of the husband of the appellant, only G. Srinivas was 16 years old, and the other children of the appellant herein were minors and they had no income. The High Court found that evidence was adduced to show that the husband of the plaintiff had substantial income and he owned an ambassador car. In view of this evidence, the High Court held that the properties at items 1 and 2 are joint family properties. So that was what had happened before the High Court. Then the contention before the Supreme Court was this. The learned counsel for the appellant contended that without any evidence, the High Court came to the finding that the husband of plaintiff number 1 had substantial income. From the list of documentary evidence produced before the trial court, nothing appears on record to indicate that there was any document evidencing the income of the husband of plaintiff number 1. Therefore, the High Court fell in an error by holding that though the properties at items 1 and 2 are recorded in the name of the appellant, that is the mother-in-law, they are joint family properties. This was the argument. In fact, the court did not go into the question of the income at all. The court dealt with this matter squarely under Section 14(1) of the Hindu Succession Act. This is what the court says in paragraph 14 of the judgment. Section 14(1) of the Hindu Succession Act has a bearing on this issue, as the properties at items 1 and 2 are recorded in the name of the appellant, is what is important, are recorded in the name of the appellant. In the absence of any evidence to the contrary in this case, the appellant, by operation of section 14(1) of the said act, is the full owner of the properties. In the facts of this case discussed above, it has to be accepted that those properties are not joint family properties, but the appellant is the sole owner of these properties. The principle laid down in section 14(1) of the said act has been read by courts in a very comprehensive manner, since the said act overrides the old law on Stridhana in respect of properties possessed by a female. They refer to AIR 1966 Supreme Court 1879. Justice Ramaswamy, speaking for the court, held that section 14(1) of the act contemplates that a female Hindu who in the absence of the said provision would have been a limited owner of the property will become full owner by virtue of the said section. Such female Hindu will have all powers of disposition to make the estate heritable by their own heirs and not revertible to the heirs of the lost male holder. They refer to about 4 or 5 decisions, and ultimately the Supreme Court concludes, in view of such consistent views taken by this court on the interpretation of section 14, we hold section 14(1) of the said act would apply in respect of the properties which stand in the name of the appellant. What's important? In respect of the properties which stand in the name of the appellant, and the appellant would become the full owner of the properties. So therefore, they allow the appeal. So therefore, when once the property is recorded in the name of the female, then section 14(1) applies. If section 14(1) applies, she becomes the exclusive owner of the property, and the property would not be joint family property. In fact, this there is another decision of the Karnataka. There are 2 decisions of the Karnataka High Court which have dealt with this matter. In fact, in 2015, 1 Karnataka Law Journal, page 698, the one sentence in this decision is very important. This is what the court has said. Even if it is presumed that the joint family, by investing its funds, has purchased a property in the name of a female member of the property, such property becomes the absolute property of the female member, and the other members of the property family have no right to ask such female member to put the property into the common hodgepodge, seeking partition in respect of the property between the members of the family. This legal aspect has been completely overlooked by the courts below. So in that case, the High Court held that even if the joint family funds were utilized for the purchase of the property in the hands of the female, then the court said, even in such a situation, the property would not be joint family property, it would be the individual property of the female. Then the third decision is the decision of the Karnataka High Court reported in ILR 2020 Karnataka, page 2697. That is Padmavati versus Jayamma. It's a bench decision of Justice Govindaraju and Justice B.V. Nagaratna. In this decision, the decision of Justice, the 2015 Supreme Court Justice Budihal was not referred to. But in that case, what happened was, the lady in whose name the property was acquired, in her evidence said that she was actually in the management of the properties of the family, and that she was receiving the funds of the joint family into her hands, and she has actually purchased the properties in her name with the joint family funds. So in view of these admissions made by the female herself, that the property was in fact purchased from the joint family funds, the court came to the conclusion that the property belonged to the joint family and not to the female. So therefore, the broad proposition that section 14(1) applies, that even if the property is purchased from joint family funds, it would be the property of the female was not pressed into service, and the court made a departure from that rule and said, when there are admissions in that regard, that the property in fact was purchased with joint family funds, the property belongs to the joint family. So therefore, this is the second aspect of the matter which I have dealt with in the present lecture. Then the third question that normally arises is, properties are acquired in the name of some of the members of the family after there is a division of status. In fact, partition consists of division of status, number 2, and division of properties by metes and bounds. These are the two stages. In fact, a division of status may take place in some cases, and the actual partition may be postponed. In fact, the situations in which a division of status takes place is in a situation where a member of the joint family dies. Where a member of the joint family dies, there is a notional partition by reason of the death of a member of the joint family. And therefore, notionally, there is a division of status. And number 2, when one member of the family conveys his intention to have a partition of the properties by issue of a notice. If a notice is issued and there are number of, and it is brought, and this intention is brought to the notice of all persons who are entitled to a share at a partition, then that would result in a division of status, though a partition actually by metes and bounds does not take place. Or the third situation is where a suit for partition is filed. Immediately after a suit for partition is filed, there is an unequivocal expression of an intention to separate from the family, and in such a situation also, there is a division of status. In fact, when once a division of status takes place and the karta continues to be in the management of the family and he acquires properties even with the aid of the joint family income, what would be the character of those properties? So therefore, in the Supreme Court has said, in year 1972 Supreme Court, page 1279, that is, if a member of the joint family remains in possession of the entire properties of the family after a severance of status, there is no presumption that the property acquired in his name must be regarded as acquired for the family. Where, this is what is important, where rents and profits are received by the member in possession, he would be liable to account for the same. But the funds in the hands of that member does not become impressed with any trust in favor of the other members. Therefore, if such a member acquires property with the funds in his possession, the other members could not claim any share in this property. So therefore, this is what is important. So therefore, suppose a notice is issued and the manager of the family who is in possession of joint family funds, which is acquired by him subsequently, purchases some properties. In fact, he is liable to account for the funds, but the property does not get impressed with the character of joint family properties. And the property remains to be the self-acquired property of the manager because it is acquired after the division of status. In fact, this question has also been referred to in a decision the Karnataka High Court reported in 2012. 3 KCCR, page 422. In fact, this is a division bench decision consisting of Mohan Shantan Gowder and K. Govindarajulu. In fact, a reference may be made to paragraph page 430 of the judgment. In fact, this is what they have said at paragraph 17 at page 430. It is needless to observe that partition brings severance of status between the co-partners. The members become tenants in common. Subsequent acquisition by a member, even with joint family funds in his possession belonging to him alone, even with joint family funds in his possession belongs to him alone, and the other members cannot claim a share therein. In they refer to the Supreme Court decision. If one of the members remains in possession of the entire property, even after severance of status, there is no presumption that the property which is acquired by him after severance of status must be regarded as acquired by him after the severance of status. And the same must be regarded as acquired for the family. Where rents and profits are received by the member in possession, he would be liable to account for the same. But the funds in the hands of the member do not become impressed with any trust in favor of the other members. Therefore, if such a member acquired some property with the funds in his possession, the other members could claim no share in this property. So therefore, this principle will have got to be kept in mind. Where large number of properties are there and a notice is issued for seeking a partition, and if these properties are acquired subsequent to the issue of the notice, then it would be the exclusive property of the Karta, though he has acquired these properties with the joint family funds in his possession. So therefore, and there, in fact, if we go to Vinita Sharma's case, there are a few passages in Vinita Sharma's case which throw a doubt on the proposition that where a member of the family dies and a notional partition takes place, where a notice is issued and a partition takes place, the notional part and a severance of status takes place. When a suit is filed, the severance of partition takes place. This is the established law prior to Vinita Sharma's case. But however, the Vinita Sharma's case has expressed some doubts in this regard, and the law appears to have changed, and the principle has not, in fact, the earlier decisions have not been overruled in this regard. In fact, this is what, in fact, there is one decision of the Supreme Court in Gurupadappa Kannappa Magadam's case, where the principle with regard to the notional partition has been discussed in great detail by Justice Chandrachud. The court makes a reference to the decision in Vinita Sharma's case, and this is what the court has said. The only question involved, that is in that Gurupadappa's case, this is what the Supreme Court says. The only question involved in the aforesaid matter was with respect to the explanation of Section 6 and the determination of the widow's share. In that case, the question was not of fluctuation in the co-partnership body or by a legal provision or otherwise. Everything remains static. No doubt about it. The share of the deceased has to be worked out as per statutory fiction of partition created. However, this is what is important. However, in case of change of body of co-partners by a legal provision or otherwise, unless and until the actual partition is finally worked out, rights have to be recognized as they existed at the time of the final decree. It is only the share of the deceased co-partner and the heirs are ascertained under the explanation to Section 6, and not that of other co-partners, which keep on changing with birth and death. So in fact, when once a notional partition takes place, the shares of all the co-partners, they get crystallized. That's the established principle. In fact, the Supreme Court has said in Vinita Sharma's case that no, when the body of co-partners itself changes, what is contemplated under Section 6 is only for the purpose of ascertaining the share of the person who died. And his share will have got to be worked out by succession under Section 8. And it does not bring about a division of status. That is what the Supreme Court has said. Then there is another paragraph that is at paragraph 99 in Vinita Sharma's case. This is what the Supreme Court has said. Once the constitution of the co-partner changes by birth or death, shares have to be worked out at the time of actual partition. The shares will have got to be determined in the changed scenario. The severance of status cannot come in the way to give effect to statutory provision and change by subsequent event. The statutory fiction of provision is far short of actual provision. It does not bring about the disruption of the joint family or that of a co-partner is a settled position of law. So therefore, the court goes to the extent of saying that it does not bring about a disruption of the joint family or the co-partner. For the reasons mentioned above, we are also of the opinion that mere severance of status by way of filing a suit does not bring about the partition till the date of the final decree. Change in law and change due to subsequent event can be taken into consideration. Then in the operative portion of the judgment also, they make a reference to this, and this is what is stated in the operative portion of the judgment at subpara 4 of para 129 in Vinita Sharma's case. The statutory fiction of partition created by proviso to Section 6 of the Hindu Succession Act 1956 as originally enacted did not bring about the actual partition or disruption of co-partner. The fiction was only for the purpose of ascertaining share of the deceased co-partner, and when he was survived by a female heir of class 1 as specified in the schedule of the Act 1956 or a male relative of such female. The provision of the substituted Section 6 are required to be given full effect, notwithstanding a preliminary decree has been passed. The daughters are to be given a share in the co-partner equal to that of a son in pending proceedings for final decree or in appeal. So therefore, the whether this decision in Vinita Sharma's case, which says that the death of a co-partner does not bring about a division of status, issue of a notice, filing of a suit, none of these things brings about a division of status, whether such a rule would apply only to cases where there are women in the family who get the status of co-partners by reason of the amendment of Section 6 of the 2005 Act. In the absence of female co-partners, then my feeling is that the law with regard to division of status established by a large number of decisions would still continue to apply. So therefore, this is a gray area created after the Supreme Court decision in Vinita Sharma's case, and the confusion will have got to be cleared by the Supreme Court itself, and the law is not very clear on this aspect of the matter. Then I would go to one other question. Normally what happens is in large number of cases, there will be no registered document evidencing a partition. The clients come up with an unregistered document bringing about a partition, a list of properties, and all those documents will be brought to you for preparing a defense. If it is a document under which an actual partition has taken place, in such a situation, under Section 17 of the Indian Registration Act, registration is compulsory. If it is not registered, the document would not be admissible in evidence. Number two, if the document says that we have already partitioned the properties and what is being recorded is only a record of a previous partition, in such a situation, the court has held in a large number of cases that the document does not require registration and it is admissible in evidence. Number three, there are cases where nothing is written, only 4 or 5 schedules indicating the properties allotted to the shares of various persons is mentioned. Only list of properties are available. The list of properties are signed by all the persons who are entitled to a partition. In such a situation, the courts have held that mere list of properties indicating the properties allotted to the shares of different sharers, it would not require partition. So therefore, when these documents are placed before the court, we have got to first look at these documents and honestly decide whether the document is admissible in evidence or not. And if the document is admissible in evidence, your claim for partition can be upheld on the basis of the document. If the document is inadmissible in evidence, what happens? Then I would like to invite your notice to one decision of the Supreme Court reported in AIR 1968 Supreme Court, page 1299, Shiromani versus Hemkumar. In fact, in this decision, the document was held to be inadmissible in evidence. Exhibit D4 was a document. In fact, I would only read 1 or 2 lines. We are satisfied in this case, upon examination of the evidence, that the intention of the parties was that Exhibit D4 should be the sole evidence of partition. Since we have held that Exhibit D4 is not admissible in evidence on account of non-registration to establish when the property was so partitioned, it is manifest, this is what is important, it is manifest that no oral evidence is admissible to prove any subsequent partition having regard to the provisions of Section 91 of the Indian Evidence Act. So therefore, you have got an unregistered partition deed. Mutations have taken place. All other documents indicate that the properties are, persons are residing separately from each other. So therefore, when once you produce such a document and the document is held to be inadmissible, you are totally gagged. You cannot lead any other evidence to show that there was actually a partition. If the document is held to be inadmissible in evidence, oral evidence regarding partition is not admissible under Section 92 of the Act. Therefore, as a defense counsel, what is it that you can do? The best way is not produce, don't produce the unregistered partition deed, which would be inadmissible in evidence. Take a plea that an oral partition has taken place and the oral partition has been acted upon. And you can, in that such a situation, an oral partition is tenable in law. Such a crime can certainly be upheld. And in such a situation, you can also show that mutations have been accepted in regard to the oral partition. Persons are in possession of those properties which are allotted to their shares. They have paid condign separately to the properties allotted to their share. So therefore, your plea of oral partition could be substantiated by the conduct of the parties subsequent to the partition. So if this is established, you will be able to justify a oral partition. If you produce the document, then you will be gagged. Document is inadmissible in evidence. No oral evidence can be given under section 92. So therefore, this important factor will have got to be borne in mind. And it is at the time of filing your defense, you have got to take a proper stand in this regard. In fact, that oral evidence of partition would be admissible, where the document is held to be inadmissible in evidence. That would, there is another decision of the Karnataka High Court reported in 2015, 5 KCCR, page 373. This is a decision of Justice N. Kumar, Venkataswamy versus Annamma. I read only one sentence from the head note. Unregistered partition deed, admissibility of, held. Such document must be registered. If not, the same is inadmissible in evidence for want of registration. Then the next portion is important. And oral evidence to prove its terms is not permissible to be adduced. Oral evidence to prove its terms is not permissible to be adduced. So therefore, when a document like that is brought before the court, you will have to be very careful to decide whether the document should be produced or not. And there is also one other important thing. In some situations, it so happens that after such a document has come into existence, your client has purchased large number of properties. Say, he is the manager of the family. Even with the funds of the family, he has purchased these properties. Then this document could be relied upon to show that there was division of status, but the document cannot be relied upon to show that there was a partition by metes and bounds. So therefore, if on examination of the entire matter, if you find that putting this document, if you can prove a division of status very clearly, then and the properties acquired by your client subsequent to that date are large in number. And if you want to protect those properties, though your claim for partition by metes and bounds cannot be upheld, in such a situation, you can take the risk of producing the document. Therefore, at the time of preparing this defense, you will have to be very careful. Once you take a stand into the written statement, we cannot resile from that stand subsequently, and therefore this question will have got to be very clearly kept in mind while preparing a defense. Then there is one other aspect of the matter about which I would like to draw the attention of the audience. That is, there are situations where one person in a joint family walks out of the family and a registered release deed is executed. Under the registered release deed, probably a few properties are given and sometimes a small consideration is shown for the release. Then it would be very difficult for you to convince the court when properties worth crores of rupees are there and a release deed, under the release deed, when 500 or 10,000 rupees is given under the release deed. On the face of it, it would appear that the release is not a document which was intended to be acted upon. In fact, this question was considered by the Karnataka High Court, and the Karnataka High Court has said that a release is a unilateral document. A release can be executed for consideration or even no consideration. Even in such a situation, the release would be valid. In fact, this is a decision of the Karnataka High Court reported in 2006, 3 Karnataka Law Journal, page 177. This is a bench decision, and I would draw the attention of the court to one important, in fact, this was the argument that was advanced before the court. It is not, Sri G.S. Vishweshwara, I read from paragraph 56. Sri G.S. Vishweshwara, the learned senior counsel for the second appellant, contends that the document Exhibit D6 is void, hit by Section 25 of the Contract Act, since the consideration of ₹1 to each of the daughters, that is sisters, for release and relinquishment of their rights to claim a share is illusory and is no consideration in the eye of law, by placing reliance upon the decision of the affairs court in so-and-so, and the decision of the division bench of this court in Sajan Shah versus S.N. Dondusa. Sri Narayan, learned counsel for the first appellant, adds that ₹1 consideration to each of the sisters would shock the conscience of the court, an ingredient which should weigh heavily with the court of equity. So therefore, that was a case where ₹1 was given to the sisters as consideration for the release. Then the counter argument, this was the counter argument that was placed before the court. Countering the plea of inadequate consideration, Sri Ron places reliance on the decision of the special bench of the Madras High Court in the case of Chief Controlling Revenue Authority Board of Revenue Madras versus Dr. K. Manjunath Rai, wherein it is held that a release in law may be effected either for consideration or for no consideration. Then, considering this question, this is what the court said at paragraph 71 of the judgment. It is not, no doubt, true that the covenants in the partition deed Exhibit D6 read that the sisters have released and relinquished their right to claim a share in the family properties for a consideration of ₹1 each. It is right that relinquishment deed is effective with regard to joint family properties, but not separate properties which could be done only by a conveyance. At a partition, it is open to the parties to arrive at an arrangement which according to them is just and equitable in the circumstances of the family at that time. A partition is an agreement between 2 or more persons who are bound by it, whereas a release deed is a one-sided document which binds the executant alone. A release in law may be effected either for consideration or for no consideration. We draw, then that is what the court has said. So therefore, see, in many cases it happens. In fact, the release deeds would have been executed by sometimes it happens that there will be intercaste marriages of some of the daughters in the family. And at that time, release deeds would have been executed. And the entire consideration would not have been shown in the release deed. And some large number of gifts would have been given. And in the release deed, a small property or a small sum of money would have been shown. And normally, these documents are attacked on the ground that the family owned crores of rupees and the release deed is for a paltry sum. So in such a situation, you should be able to justify that the release deed, though for a small sum, is recognized by law as a release deed is a unilateral document and it could be either for consideration or for no consideration. So therefore, these principles, unless these principles are clearly in mind, the defense would not be very effective. Therefore, the entire situation will have got to be analyzed. You have got to carefully hear your client understand the situation and then prepare the pleadings in this case, because ultimately, if your claim is not supported by proper pleadings, the claim will not be ultimately upheld. This is one other important factor. Then there are cases which are before courts where alienations would have taken place long back. And in such situations, the grandsons of the family, they come before the court after long passage of time, and they question these alienations. Then in such a situation, what are the questions that should be in our mind? The most important question that should always remain in our mind is to find out whether the person who has come before the court as plaintiff was born on the date when the alienation is made. If he was not born at all on the date when the alienation is made, he cannot challenge the alienation at all. And therefore, the dates of birth, the dates of alienation, all those things will have got to be properly appreciated in conducting the defense. In fact, this is a settled position, but anyway, I would invite your attention to a decision of the Supreme Court reported in 2013, SCCR 746, Rohit Chauhan versus Surendra Singh. This is what the Supreme Court has said. The moment a son is born, properties become co-partnership property, and the son acquires an interest in the co-partnership property and becomes a co-partner. For this reason, an alienation made before his birth cannot be questioned by the co-partner. So these are no doubt very settled principles. But what happens is, in trial courts, unless you are able to justify your argument by authorities, you would not be able to persuade the court to come to a particular conclusion. Though these are obvious legal propositions, it would always be better that we are armed with proper authorities in this regard. Then the next question is limitation in a suit for partition. See, is there a limitation in a suit for partition? In fact, in large number of cases in my 50 years of practice, daughters attack alienations which are made by all the male members of the family long back, and the purchasers would have formed layouts. They would have sold the properties to various persons also. In such a situation, is there any limitation for filing a suit for partition? In fact, this question has been considered by the Karnataka High Court in a decision reported in 2015 to KCCR 1437. In fact, in this case, this is a bench judgment, and in this case, Justice Kumar has analyzed the entire law on this question by referring to various authorities, and we may make a reference to paragraph. I would, in fact, this is one important question, that a suit for partition has practically no limitation at all. This must be always in our mind. And this is what, in fact, co-ownership has been discussed in the earlier paragraphs. And this is what is stated at paragraph 64 of the judgment. Merely because one co-owner is in exclusive possession of the property and the other co-owners are residing separately, it cannot be said that the co-owner who is not in possession or ousted from the property. In the absence of ouster, hostile title, mere exclusive possession would not constitute either adverse possession or ouster. Even in case of alienations, though the alienee is put in exclusive possession of portion of the property, as the property is not divided by metes and bounds, he cannot claim the exclusive title in the property for the co-owner who is not a party to the alienation is deemed to be in possession of the property. In fact, that was a case where the sisters were married in 1958 and the father died in 1972 and the suit was filed subsequently. In fact, I read from paragraph 67 because it is settled principle of law that mufusal pleadings must be liberally construed and pleadings must be construed as a whole. In the instant case, absolutely, there is no plea of adverse possession or ouster in the written statement. No doubt, applications are filed for conversion of land for non-agricultural purpose. Layouts have been formed and approval has been obtained. Even these acts cannot constitute a hostile act or assertion of hostile title against the co-owners. At best, it may amount to development of the properties by those in charge of the same and managing their properties. So therefore, see, the plea of ouster is something which is very difficult to prove. In fact, in one of the cases which I was conducting, I was appearing for the plaintiff. I was appearing for the defendants. The plaintiff had filed a suit, relationship had been admitted. Here he was residing for almost 30 or 40 years in Andhra Pradesh, and he came back and filed a suit for partition. In fact, there was nothing on record when I spoke to my client to say that there was ouster in the that could be pleaded. But in the course of evidence, it so developed that the person who had gone away about 30 or 40 years back, the reason why he went away was this. He eloped with his brother's wife. See, if this one situation was put in the pleadings, I could have substantiated my claim for ouster, because this particular fact was not brought to my notice to my clients. I did not plead this. Ultimately, I could not succeed on this plea because there was no pleading in this regard with regard to ouster. So therefore, see, in a partition suit, whatever defense you might have taken, one thing must be in your mind. You cannot normally succeed on a plea of ouster or adverse possession, however strong the plea is. And even if the suit is filed after 100 years, then even then the suit would not be barred by time. In fact, that's exactly what the Karnataka High Court has said in one decision. 2015, 5 Karnataka Law Journal, page 478, D. Ramakrishna versus D. Balakrishna. If you, in fact, I would read only 1-2 sentences in this, in this matter. That is, by making a reference to the last portion at page 497. It is settled law that even 100 years of possession will not create title and until there is a plea of adverse possession. Unless and until there is a plea of adverse possession, the question of title does not arise. In the case on hand, there is no plea of adverse possession. The seventh defendant do not admit the title of the plaintiff. The plaintiffs do not admit the title of the seventh defendant. So the issue is who is having title. There is no question of limitation because there is no plea of adverse possession. That was also a suit for partition. In fact, the law of limitation is always intended to limit the exercise of the right. And there are 2 situations which are not met by the law. One is a suit for partition. In fact, in a suit for partition, if a person acquires a right as a co-partner or as a sharer at some point of time, some limitation should be fixed for exercising that right. If a suit could be filed after 100 years, imagine what should happen to the purchasers. What should happen to the number of transactions would have taken place. Therefore, it is high time that the legislature should step in. In fact, even after the amendment of Article 65 of the Indian Limitation Act, if the plaintiff proves title and if the defendant does not prove adverse possession, even if 100 years has elapsed, the suit for declaration of title should succeed. So therefore, I feel that having regard to the object of the law of limitation, there must be some limit for a sharer or a co-partner or for a person who has become the owner of the property to exercise that right, either for recovery of possession or for injunction. A limitation must be there. If that limit, otherwise, there will be the whole title would get unsettled even after a large number of years. This is an area where the legislature should step in and take remedial measures. Then there is one other situation which we normally come across. There is a situation where a minor challenges the alienation made by the father. He was a minor at the time the property was sold, and then the son challenges the alienation. Then in such situations, Section 60, Article 60 of the Limitation Act would be applicable. Therefore, such a suit will have got to be filed within 3 years from the date on which the minor attains majority. If the suit is not filed within 3 years, after the minor attains majority, the suit would be barred by time. And one other important factor is that there must be a specific plea for for cancellation of that document, because the document is executed on behalf of the minor. The minor would be bound by the sale deed. If there is no prayer for cancellation of that document, then even in such a situation, the suit would not be entertained. In one particular case, the Supreme Court said that an application for cancellation of the sale deed, or with a prayer that the sale deed does not bind him, should be made within 3 years. So therefore, there was a lacuna in the plight. An application was filed for amending the plight. The court said that you cannot seek an order for cancellation of this document without beyond 3 years, and therefore the application for cancellation of the document was also rejected by the court. In fact, I would invite your attention to few decisions in this regard, and because of paucity of time, I would not go into these cases in detail. That is, there are two Supreme Court decisions. AIR 2001 Supreme Court, page 2607. That is, in a suit by a minor challenging the alienation made by the guardian, relief for setting aside the sale deeds should be made, and this relief can be claimed by the minor only within 3 years from the date of attaining majority. Further, it is also necessary to seek a prayer for setting aside the sale deeds, as otherwise the suit would not be maintainable. In fact, I would request every one of you to read this decision. AIR 2001 Supreme Court, page 2607, and another decision is AIR 2016 Supreme Court, 1666. That is Narayan versus Basha Saab. Then there is one other decision of the Supreme Court in AIR 2001 Supreme Court, 2607. In fact, these principles are established and they are followed by a number of decisions of the Karnataka High Court. And to make a reference to two recent decisions, I would say 2014, 2 KCCR, page 1587, HM Rudraradhya versus Uma and others. Then 2011, 1 Karnataka Law Journal, page 49, that is HD Hanumantappa versus Mohammed Saab and others. So therefore, see, we will have to carefully find out while preparing a defense whether we can take a successful plea to say that the suit is barred by time. In fact, the Kerala High Court, while considering the limitation for a suit for partition, where properties are alienated, they have evolved one principle. This is what the Kerala High Court has said. If at the time when the property is sold, the vendors profess to be the exclusive owners of the property and they sell the property, then in such a situation, the suit by the other co-sharers who have not joined the sale deed will have got to file a suit within 12 years from the date of the sale. So therefore, what is professed to be sold is not a portion of the property. The entire, as if the vendors are the owners of the entire property is sold. Therefore, the court holds from that day, the adverse possession would begin to run. And if the vendors say that they are not the owners of the entire property and what they are selling is an undivided portion of the entire property, and though possession of the entire property is delivered to the purchaser, in such a situation, adverse possession does not begin to run and the suit would not get time barred. So therefore, it is necessary for the legislature to properly remedy these areas before a conclusive conclusion be arrived at in respect of such situations. And this is another important factor that has to be kept in mind. Then there is one other area under section Article 65 of the Limitation Act. In fact, Article 65, explanation 2, deals with a case where a person claims title to the property on succession to a female. And in such a situation, what would happen if the suit is not filed within 12 years from the date of death of the female? In fact, one decision of the Supreme Court is there in this regard, that is ILR 2014-2006, Karnataka, page 2291. It is Jagat Ram versus Varinder Prakash. In this decision, the plaintiff filed a suit after a period of 12 years from the death of the last female holder who was the owner of the property. And the court held that because the suit was not filed within 12 years from the date of death of the female under whom the plaintiff was claiming title, the suit was barred by time. In fact, I would refer to a particular portion of the judgment of the Supreme Court, that is paragraph 6. In our view, the High Court was right in holding that the suit was barred by limitation. Article 65 of the Limitation Act 1963 prescribes the period of limitation for possession of immovable property or any interest based on title where the suit is by a Hindu or a Muslim entitled to possession of immovable property on the death of a Hindu or Muslim female. Section 65B in express term provides that the possession of the defendant shall be deemed to become adverse only when the female dies. Now, that's the wording of the statute itself. The limitation prescribed is 12 years, beginning from the date when the possession of the defendant becomes adverse to the plaintiff. Learned counsel submitted that in view of Section 65 of the Indian Limitation Act 1963, the suit had to be filed within 12 years from the date on which possession of the defendant became adverse, and therefore it was immaterial as to when the Hindu female died. It is not possible to sustain the contention because the article itself provides that possession of the defendant shall be deemed to become adverse only when the female dies. Thus, there is no scope for the argument that limitation does not run from the date on which the Hindu female died, and it would start running from some other date. In our view, the court has rightly held that the suit should be filed by the plaintiff within 12 years of the death of the Hindu female, namely Srimati Krupi, and the same not having been filed within 12 years was barred by limitation. In fact, this decision is subsequently distinguished by the Supreme Court in AIR 2017 Supreme Court 2491. There, the Lordship of the Supreme Court have distinguished this earlier decision by saying that where the claim made is under the female, so where the female had a life interest in the property and her interest was not exclusive, and where the female was not the exclusive owner of the property, then this article would not apply. If the female is a limited owner of the property, this article would apply. And there is one other decision of the Karnataka Court, Supreme Court, which is reported in 2014, 5 cases here, page 154. In that decision, the Supreme Court has said Article 65B would not apply to suits for partition. So therefore, unless these 3 decisions are carefully read, it would not be possible to understand the nicety of the interpretation of Article 65B of the Indian Limitation Act. Then there is one other question which normally arises in the courts is this. In fact, the property belongs to the father. The father would have sold the property. And normally it happens that the sons are also included as vendors in this property. So therefore, when this alienation is challenged, the plaintiff would say, look at the sale deed. All the members of the family have joined together and sold the property. So therefore, obviously the property is joint family property. Therefore, you cannot contend that the property is not joint family property at all, merely because the property is purchased by the father in his name. In fact, such a contention is repelled in one of the, in fact, there are a few Supreme Court decisions also in this regard. I would refer to a decision reported in AIR 2004 Karnataka, page 479. The contents of the sale deed, I read from head note 2. Sale of property by father. Sale deed retrieves that the property in question was self-acquired property. Mere fact that he joined his sons in the execution of the sale deed would not be a ground to infer that property conveyed under the sale deed is joint family properties. They also further say, amongst Hindus, it is common knowledge for the children of the vendor to join the execution of a sale deed of immovable property for and by way of abundant caution. Merely because the son was joined in the execution of the sale deed, it cannot be inferred that the immovable property conveyed under the sale deed was ancestral property. In fact, it would not. In fact, it could sometimes be even contended that the property is acquired, is thrown into the common hodgepodge, and because the property was thrown in the common hodgepodge. All the persons have also joined and have executed the sale deed. The court says you have got to examine who has acquired the property, whether it acquired the character of self-acquired property or joint family property independently. Merely because all the co-partners, the father, sons, everybody has joined, it does not mean that the property is joint family property and the plaintiff would be entitled to a share. Now, and there are a few technical contentions which are generally taken. In fact, sometimes it happens that some one or two properties are partitioned, some properties are not partitioned. It's admitted. So the house property was partitioned, we began to live separately. The other properties are not partitioned and other things. Normally, the presumption is that the family is joint, and it is for the person who says that the property, that the family is divided to prove that it is so divided. In fact, the Supreme Court has said, if there is an admission that one property is divided, then it would mean that all the properties are divided. That would be the presumption. In fact, I would invite your attention to a decision of the Supreme Court reported in 2004, SAR Civil 552. In this case, this is what the Supreme Court has said. I read only one sentence from this decision. Once a partition, in the sense of division of right, title, and status, is proved or admitted, the presumption is all joint family properties was partitioned or divided. So therefore, when once the partition of one property is admitted, the presumption is that all the properties are also divided. So therefore, if these principles are in our mind, evolving a defense would be quite easy. Then there are cases where all the properties of the family are not included in a partition suit, and one property is excluded, and it is brought to the notice of the court that that property is excluded. The normal rule is all properties of the joint family should be included in a suit for partition. The principle is this. In fact, the question of a suit being bad for partial partition would arise only in cases where an alienation of some of the properties is made, and the alienees are also parties to the suit. In such a case, what happens is, if the court should hold that the plaintiff is entitled to a share in the properties which are alienated, then the court can direct an equitable partition of all the properties of the family, which are alienated and not alienated, and direct that the properties which are sold be allotted to the share of the co-partners who have sold this property, so that the rights of the purchaser in the property which are purchased by them could be upheld. This is a rule of equity. In fact, according to me, in a suit for partition, where the properties are not sold at all, and where one or two properties are not included, then what happens is, merely because those one or two properties are not included, the suit cannot be dismissed, because the question of adjusting equities are not there. Here, all the sharers are parties to the suit, and if one or two properties are not included, a separate suit cannot be filed, because it would be barred under Order 2 unless leave is sought as to why those properties are not included in the suit for compelling reasons. So therefore, a second suit for partition in respect of properties which are not included in the earlier suit is also maintainable in certain circumstances. Or even if the second suit is not maintainable, the worst thing that is going to happen is that the plaintiff cannot file another suit in respect of those two properties, because the second suit would be barred by order 2, rule 2, and therefore a second suit could not be maintainable. Therefore, the principle of the suit being barred for partial partition, according to me, would apply only in cases where there is an alienation and alienees are parties to the suit. Where the alienees are not involved, if a few properties are not included in the suit cannot be dismissed as being one for partial partition. Therefore, my submission is, and in situations where a suit like that would not be maintainable, I would only make a reference to two decisions, a few decisions of the Karnataka High Court. That is 2004, 3 KCCR, page 1637, UG Srinivasa Rao versus Vijay Kumar. Another decision is 2011, 4 Karnataka Law Journal, page 2461, that is GM Mahendra versus GM Mohan and others. And the earlier decisions are ILR 1998 Karnataka, page 681, and ILR 1989 Karnataka, page 1895. Therefore, these principles would be very helpful for us in preparing a defense in a suit for partition. The first and the most important thing is, at the time when you prepare a defense, sit with your client, assess all the facts in detail, try to find out what facts must be put in the written statement, what facts should be elicited in the cross-examination, what facts should be elicited by your client. Make a detailed notes. Get all the relevant documents before you file a defense, and then prepare a defense in this case. Therefore, you cannot prepare a defense at the time of the evidence. You cannot prepare a defense as the case evolves. You must, if you want to be a good lawyer, you must apply your mind before you prepare a written statement in the case. Have the entire facts clearly in your mind, then proceed with the matter. Then only you can defend your client effectively. Therefore, these are a few thoughts which have come to my mind, which I have used often in my 50 years of practice, and I have shared my ideas with you. There are many other novel defenses which may be available, and it is for us to explore depending on the facts of the case which are before us. And therefore, what I have stated is not the end of the matter. This is only a beginning. This is only an idea which I have given, how you should think about the matter and evolve your own defense by keeping in mind the principles of law clearly before you prepare a defense. This is what I want to place before you. And thank you very much for having given me a patient hearing. Thank you, Mr. Chatra, for having spared 2 lectures in respect of this subject.
No,
thank you. Thank you.
In fact, the way you share knowledge, any amount of lectures would always be short because you explained in such a elucidated manner. And that's why I was just checking it out on the YouTube and Facebook. We don't even have any questions because you've elucidated in such a nice manner. Yeah. So thank you, sir. Stay blessed, and everyone enjoy the festive season. Thank you.
Thank you very much, sir. Thank you.